Yeah, for those of you that don't know, we do have a Zoom YouTube channel that you can click on videos and see all of our webinars that we've done in the past on there. So if you want to see what we've done on UR denials and IMR or vouchers or SIBTF or even Jetfiler, you can find them on that YouTube channel along with a number of others. So it is 12:05 and we're going to go ahead and get started. So I'm John Blake. I'm Director of Sales at Gemini. I'm thrilled to be joined here by Marie Ivey, who is our account manager in the Bay Area, as well as Robert Mack from Kurlander, Burton, and Mack in San Francisco. And they are going to be discussing the new MedLegal Fee Schedule and how that affects everybody. And so with that, I'm going to go ahead and turn it over to Marie.
Awesome. Thank you so much, John. Like John said, we're going to review the new MedLegal Fee Schedule. This has been a hot topic implemented a couple months ago. It's been interesting to see how things develop. And actually having Mr. Applicant Attorney Rob Mack with me, he did a whole webinar about this for CAW. So he's got the insight and expertise to share with us. I'll let him say a little bit of words about himself and what we're going to explain and walk through here. So Rob?
Sure. First of all, thanks for having me here, guys. I appreciate it. Appreciate you trusting me to give people the information that hopefully that they'll find interesting and useful in their practice. You know, first of all, I'd just like to say anything I say here is my opinion. It's not, I don't work for Gemini. So if I say anything that you don't like, don't blame them. That's on me. And also, yeah, I mean, I just think before we get into the nuts and bolts of what this is, it is an important topic because it's something that affects each of the different parts of the industry. It's going to affect applicant attorneys, QME doctors, defendants, copy service people. So it's important that everyone kind of understands it. A lot of it is going to just be working with people to get the right information to the right people and do it in the correct way. So again, thanks for having me, and hopefully everyone will get something out of it. And if at the end, if anyone has any questions, they're free to get in touch with me, and hopefully I can help them there.
Yeah, awesome.
On that note, before we get started, one more thing I wanted to say. If you do have questions for Rob, there is a place on the bottom of your screen that says Q&A, and you can type them in there and we'll go ahead and get to them as we have time.
Awesome. Yeah, thank you guys. So we have the main overall one. Like we said, this is a new MedLegal Fee Schedule. It became effective April 1st, 2021 this year. So in essence, Rob, what is this new MedLegal Fee Schedule? We have Regulation 9793N, and how does it apply to applicant attorneys primarily?
Sure. The very basic of it for people that don't know anything about what a MedLegal Fee Schedule is, essentially what it is it's the regulation that the parties then look at to use to figure out how much the QMEs are going to be paid for the various parts of the case that they work. So when you have a QME in your case, there's several different things. You know, there's an initial evaluation, there's an initial report, there's possibly a supplemental report, there's possibly a deposition, there's possibly some sort of record review. So what this new MedLegal Fee Schedule is trying to do is make it easier for everyone to figure out exactly how much the doctors are going to be paid for their services at each step throughout the process. And so why it's important to applicant attorneys is a few things. First and foremost, we know we don't pay for any of these services, right? We know that the insurance company will pay the doctors directly for each of the steps involved, but we need to understand what it's going to cost because that could affect your case. For instance, and I'm going to go through this a little bit later, but there's page limits for each one of these documents that they're going to be sent to the doctors. And if they go over the page limit, it costs more money. So what the insurance company is going to do then is exert the medical records. So it's important that you understand that because now they're not going to be sending each and every medical record, or it's possible they won't be. So you need to understand that. You need to make sure that the medical records that you want to be sent to the doctor actually get sent to the doctor. Also, it changes the deposition costs. And if you're an applicant attorney and you want to do a deposition with the QME, you have to pay up front. So you need to know how much you're going to pay up front for that. Also, just on an overall kind of idea, it's important to understand that insurance companies, for each case, they have a reserve. They have a certain dollar amount at each time that they're going to allocate to a case. And so you want to, in a sense, kind of help keep these administrative costs down for the defense attorney that you're working with, because you want that money to go to your client. You don't want it spent on administrative costs. Also, you want to make sure that the QME you're dealing with is happy. You want to make sure that they get paid. You want to make sure that there's good QMEs. So there's a lot of reasons why this does apply to an applicant attorney, even though you might think to yourself, why would I care? The insurance company pays for all this. What does it matter to me? It actually does matter both on the micro level for individual cases, and it definitely matters on the overall spectrum of things for a few different reasons that we'll go into, this hour.
Definitely. Awesome. Well, thank you. No, that's great insight. I know going out and talking with other attorneys, everybody's got their own way of navigating, handling those cases. Some are more meticulous on what records are sent, what do they have, and some do leave it more up to the other side to figure out and sort through. So having that background understanding is great, especially with this new fee schedule that's going to have to limit you on those and what your case could potentially cost. So prior to this effect, what was the protocol for the process before of sending these records and getting them to the doctors?
Yeah, previously the way that the doctors were paid for, I guess back up a little bit, a lot of this has to do with the actual sending of the records to the QME. And one of the main parts of this new regulation is they set page limits for each evaluation or supplemental report. And then if the medical records go above that limit, it's $3 a page. So if you send, and most page limits are 300 pages. So if you send 1,000 pages of review, that's 700 times 3, that's $2,100 just for that part of the medical review. So that's kind of just a little bit of a background. And previously it had been based on how much time the doctor took to review the records. And there was a lot of issues with that. For one thing, how could you ever really know how long it takes a doctor to review the records? There was skepticism on the insurance company side that the doctors weren't actually even reviewing the records, that they would hire someone else to review them, but they would sign under the penalty of perjury at the bottom of their report saying they reviewed the records. So there was an issue with that, just didn't really make sense. And it did lead to some issues with the doctors not getting paid because they would get into a fight with the insurance companies about the billing. And so what this is trying to do is make it simpler. It's not about time spent. It's just about how many pages of records are being sent, and at what stage of the process of the QME process you're in has different pricing. There's also different pricing for certain specialties such as psychology, because it takes a little bit more time to review those records than, say, just a knee injury. Also interpreters, if the interpreter's involved, it increases the pricing. So they're really trying to make it easier for everyone to figure out what the pricing is. And that's important because insurance companies really want to make sure that they can predict how much things cost ahead of time. So it's really laying out the pricing beforehand and taking out that kind of subjective, how much time, less arguing about that sort of stuff. That's the main difference. The main difference was before it's about time spent, and now it's about actual physical paperwork.
Got it. That kind of leads into the next question, and I think you probably answered it, about what was the reason for this change in the schedule. So what have you seen as an applicant attorney that may have spoken to this becoming a regulation and having this labor code?
Sure. And before I answer, I'm going to say this is my own opinion about this, because I've spoken with a lot of people about this. Different people have different opinions, but I think the main reason is a few things. One, the doctors were sick of not getting paid as much as they thought they should be paid. So this hopefully will increase the amount that the doctors get in terms of the amount of time they spend. So they'll know this evaluation, I get this much, I review these records, I get this much, and then they can figure out in their own business model how to make that make sense. Similarly, it was the insurance companies were sick of fighting with them about it. So I think that this helps the insurance companies in terms of figuring out their pricing and how much it's going to cost them for these cases. I also think in terms of what's important to applicant attorneys, I think what also a big issue is right now there's a very big lack of new QMEs. Most of the QMEs you're going to find are of an age that might not be the best to have 45 clients in a week, right? So there needs to be more QMEs brought into the system. And if the system can guarantee that these people are going to be paid, then that'll encourage new doctors to come in. And us applicant attorneys, we know how many times we get a QME panel, doctor can't set in the right amount of time, or the doctors are in the same practice just because there aren't enough QMEs out there. So hopefully this new regulation will help encourage younger doctors who are straddled with a ton of debt from medical school to see this as an actual business model that they can be a doctor and they can make enough money to make it worth their while. So I'm hoping, that's my biggest hope, is that this will bring some new blood into the QME system. But I mean, I think we'd be remiss if we didn't also understand that there would not be a new regulation. If not, it did save the insurance company money somewhere. And I'm not exactly sure where yet, but that is part of it also. It should streamline things. So hopefully that's where the cost saving comes in. But yeah, mainly it's about saving money, streamlining, but also getting the doctors paid a fair and reasonable amount that should encourage new doctors to join the system. That's my opinion on it.
No, I can definitely relate. I hear constantly out there that, you know, especially with COVID that came along, that QMEs and getting those appointments set, like you said, within a timely manner has been a problem and ongoing. So hopefully this new fee schedule does help bring some kind of relief to that, you know, like you said, bring that new blood. But that leads me to the next question of how does this impact the discovery on those cases and what records you know to send or not send?
Yeah, I think it could impact it quite a bit. And I do also want to preface this with, I practice in San Francisco. So I'm at the San Francisco board, the Oakland board, San Jose. Sometimes I go up to Santa Rosa. But I know that in Northern California and Southern California, it is a little different. And from what I've been told, you know, in Southern California, there's a lot more joint cover letters that are sent to QMEs. And in Northern California, we each write our own. But the way that, you know, it works is when you write the cover letter, the insurance company, it's their obligation to send the medical records to the QME before that initial evaluation. And so if you have a client that has a decently long medical history, there could be a lot of medical records, you know, I mean, most clients, maybe it's a few hundred pages, but for some people you're getting into several hundred, 1,000, maybe more. And so with these new regulations, you're going to see that there's going to be excerpts from these medical records being sent instead of the entire file. And that's just because of that baseline. After 300 pages, it starts costing $3 a page. And so you're going to have to really start paying attention to what's actually being sent. Now, in terms of what discovery is going to be sent, you're going to see a lot more of the defense attorneys wanting to send medical records that pertain specifically to apportionment. You know, their old medical records that will show, hey, they had pre-existing injuries or degenerative changes or whatever they want to say in terms of trying to get apportionment brought up by the QME. And so you really got to make sure that when you look at the cover letter that's being sent, there should be a medical index. The medical record should be sent with it or in conjunction with it. And you got to make sure that not only the records that help them are being sent. Previously, it was pretty much assumed they would just send the whole file. You know, that was not really an issue at all. And, you know, you subpoena the records from the doctors, you get them, you put them in a packet, send them to the QME. Now, and I've noticed this even just in the last couple months, there are a lot more cases where they want to get it to 299 pages or 300 exactly or 350 and not send all of them because that's going to jack up the price. So it's changed the way that I've had to look at what's being sent to the QME and make sure that it's not just stuff that helps them, but also the important stuff that I want sent, things like diagnostic testing, initial injury reports, those treating doctor reports that are, you know, right after the injury for the first 6 months or whatever, that really show that the person was injured, show what kind of progress they're making. So it is changing the discovery process in terms of what kind of job applicant attorneys need to do prior to their client going to these QME evaluations. Also, it's changed in the sense of now, if you want a supplemental report, so oftentimes QMEs will see your client and then they'll say, hey, we want him or her to get an X-ray, an MRI, and do 10 sessions of physical therapy, and then send me the records or whatever, something like that.
Yeah.
When you do that, it is now the applicant attorney's job to make sure that when they send those records over, they comply with all the different parts of these new regulations. We're going to talk about that a little bit later, but it has made things a little more, you got to be a little more precise with it. And you really have to make sure, and this is not so big a deal in Northern California, but I know it's a big deal in Southern California. You have to make sure that you share your supplemental report request and the medical records with the defense counsel before sending them over to the QME, because if you just blanketly send 1,000 pages over to the QME without first sending that to the defense side, and now all of a sudden they get hit with a huge bill, that's going to be a huge problem. And it's possible that could get the QME thrown out, cause delay in your cases, and frankly, judges won't be very happy with you for just breaking the rules. So it has caused some issues, or not issues, but changes in the discovery process. I have not yet had a hearing about fighting over which records are being sent to the QME, but I do suspect that will happen also. So it could increase the discovery prior to the QME evaluations. And what I'm talking about there is, let's say there's 500 pages of records that the defense attorney wants to send, but I want to send 1,000 pages of records. They might say, hey, no, we're not sending that many. Some of these aren't appropriate. And they're really just doing it because they don't want to pay for that cost. So I could foresee there being a hearing based on, which records are pertinent, which ones aren't. And the main reason for that would be just so, the page limits don't get exceeded by the QME when they review the cases to keep costs down. I haven't had one of those yet. I've worked out a couple issues with that, but I foresee that coming. And just my general tip with that is, if I see situations where they're excerpted, first of all, I read the excerpts, make sure I agree with them. But then I oftentimes just call the other attorney. I think that a lot of these can just be worked out informally. So that's been so far my experience, but I do foresee in the future there could be some hearings about it.
Yeah. And we actually have a question pertaining to one of your answers. It says, even after the initial evaluation has already taken place, they said, I was under the impression when forwarding medical records to the QME after the initial evaluation has already taken place, ensuring opposing counsel is copied simultaneously is all that's required.
Sure, and I think that's true, especially if the records that the QME, or if it's like a diagnostic test or something the QME is requesting. But if you just want to then send records to the QME after the fact that you've subpoenaed later, I don't know off the top of my head specifically if you're in straight up violation of any of the 20-day period rules, but I suspect you're going to encounter a lot of blowback because you just cost them $5,000. So that they're not just going to take that lightly. So yeah, I mean, and just as a practice tip, I mean, I think that cooperating with the defense attorney in these situations is overall a very good thing. Again, because one, I think it's important to keep the costs down. Like I was saying before, keep the administrative costs down for the insurance company if you can, because that money is better off spent given to your client. Also, and at the end of the case, if they keep the administrative costs down, their client's going to be happy with them. You're going to have a better rapport with that attorney. And at the end of the case, when you're the one asking them for money, you always want the person you're asking money to like you. So I think that there's a benefit to working with them and keeping those costs down.
Yeah, no, I agree. That was something that was interesting, the caps that they have on this regulation. Coming from a copy vendor, we see, records in and out all the time. One set of records from Kaiser alone could be well over thousands of pages. So how do you know which ones are pertinent? How are you getting by and agreeing on which records you need to send or not send?
Yeah, I'd say first talking about Kaiser repeats itself over and over and over and over again. I mean, you see these records, it'll be like someone sends an email and then that email's like 13 times in the next 20 pages of records. So that stuff's easy. I think that stuff, you just kick it out. And for me, what I'm focusing on is records that show my client is currently hurt. But also I'm going to allow them to send records that they're going to use for apportionment. I don't have any problem with that as long as they're, same body type or same body part, or they have a biomechanical thing that can, somehow relate to their current injury. I'm not going to stop them really from sending the records that they want to send. I mean, they're really trying to stop us from sending records in terms of the cost. Now, I'm not going to want them to send records that have, drug, HIV, alcoholism, those sort of records. And, usually they don't want to do that anyways, but that sort of stuff I would stop also. But generally speaking, I don't have a big problem with them sending a lot of records that are, previous records if they're pertinent. I think that's just part of the deal. And that's up to the QME to decide if that really matters or not. And then, if I think the apportionment's too high, then you can do things like a deposition or something like that. But yeah, I mean, I think they're going to really be the ones trying to limit the records being sent because of the cost, as opposed to me. And so what my job is to make sure when they do limit what's being sent, that I make sure the things that I want sent are being sent. And most of that is stuff that happened after the injury.
Yeah, that makes sense. One of the other questions we had that came up is, are applicant attorneys required to send a copy of hume records to opposing counsel? If they are, which regulation or code do we know that to be?
Not really sure what that means. I mean, the QME should send their reports to both sides. And then oftentimes the insurance company serves me with another copy of it anyway, because they're usually required to serve medical records on everyone. I don't serve records on the other side unless I'm going to be sending it to the QME. In that case, I absolutely do every time. I don't want that to ever be an issue.
Got it. And they have the 20-day rule where you should be prepping these before that appointment coming up within.
Right. And I'll just say in Northern California, it does not really a big deal. Like I get emails 2 days before all the time and I don't fight with them about it. And frankly, same, like I send it a lot of times, it's 10 days and I don't get blowback on it. And I know again, in Southern California, there's the mutual letters because there's more fighting down there, but it's not an issue so much here.
Yeah, no, that makes sense. I've heard that not sending the records within a good amount of time could possibly delay the report. Have you seen anything with this new fee schedule affecting that?
I haven't. I mean, that is certainly a problem where the person goes to the evaluation, the records aren't there yet. The doctor sends something saying we don't have the records. And now it's like 2 months plus 2 months plus 2 months or whatever until you finally get the report. I haven't seen that any different. That was always a problem and it's still been a problem. But I haven't seen that. I haven't seen this new regulation change that at all.
Yeah. So there's two parts to this. There's the attestation and the declaration, correct? Yeah. Can you break those for us?
Yeah, so the main way that these regulations are set up is, like I was saying, when you show up to, or when your client shows up to initial evaluation, there's a flat fee cost for that. And then they get, as part of that, they get a certain number of pages of medical records that are included in that flat fee. And then after that, each page is $3. And so when you or the insurance company, defense counsel, send any records to the QME, they first have to say, I attest that it's exactly this number of pages. And so what I suggest people do, I mean, during the pandemic, it's been easy, which is great for me as a millennial. You just look at the computer, it tells you exactly how many pages it is, but you actually have to attest to exactly how many pages that you're sending to them, because that's how they figure out how much they get paid. Then you also have to sign a declaration under perjury that what you're saying is true. And so that's both the defense side and the applicant side have to do that. And because you are signing under the penalty of perjury, it is important that you're correct about it. I can't imagine you're going to get in trouble with the bar if you say it's 98 pages and it turns out it's 101. I don't think that matters. But I think the point is when the doctor sends the bill to the insurance company, they're going to include that in there and say, look, this is how many pages were sent. This is exactly what the attorney signed to. So here's our bill. So those are two parts. And the doctors are not allowed to, well, I'm just going to skip to the next question and explain a couple things about this. Yeah. The doctors are not allowed to review the records without them. So as part of the new regulations, it says doctors, they cannot review the records that are sent to them unless there is this declaration and attestation attached to the records and the letter that's being sent. And if you do not include it, they're not supposed to read the records. Now, I'm not exactly sure functionally that makes a whole lot of sense for a couple of reasons. Like if I send 314 pages, but I thought it was 311 pages, does that mean they don't read any of them? Does that mean they stop at 311? Does that mean that they just add $9 more to the bill? It's unclear what happens in those situations. Based on my conversations with some of the QMEs and AMEs, they're just kind of freaked out about it. And most offices have actually just hired someone, or someone's been appointed that already works at the office to straight up count every single page. So there is someone on their end who's going to count every page. Hopefully, if you can get it to them electronically, that won't be a problem. But with, as we talked about before, a lot of the doctors are, not native computer users, I would say. Still got to send them hard copies of everything. So if I'm not exactly sure what will happen if you don't do it exactly correct. I know that they're not going to read it. If you don't include the declaration, attestation at all, they're not going to read any of them. But I'm unclear what the practical kind of situation will be if that number is incorrect. I haven't had any blowback from the doctors on that yet. When it first did get implemented, some doctors actually sent me a template form that they wanted me to use for the declaration attestation. Just basically, here's the date it was sent, here's how many pages it is, here's the case that's involved, signed. So it's been pretty easy to do that, especially with just looking at the PDF and seeing how many pages it is.
Yeah, perfect. I know there were a couple attorneys that I spoke with that did have those where the page count was off by a little, but like you said, they're just navigating it the best they can, keeping that communication open. And
I mean, if the discrepancy is $30, like I can't imagine it's worth anyone's time to really fight about it. I think at some point, and this is kind of my general feeling about this, anytime there's a new regulation like this, there's going to be some egregious example that will get brought to the board, and then the board will make some sort of decision that we all can kind of live with or have to live with about it. But so far, I haven't seen any of these sort of egregious examples being brought up to the board. But I suspect that'll happen sooner rather than later.
Got it. So when I was out talking with a bunch of different attorneys, like you said, some of them have different feels. We know ultimately it's the responsibility of the opposing counsel or insurance to send the records. But on these cases, who is responsible for sending them? Does it matter, or what's
for the initial evaluation, it is actually in the regulations that the insurance company has to send the records. But after that, I think that it's important for the applicant attorney to take it upon themselves, especially if the records are for things like an X-ray, an MRI, things like that, to send them. But for the initial evaluation, it is the job of the insurance company, as per the regulations, to send those records. And that's why, as an applicant attorney, knowing that, you've got to make sure they send the correct records. If they're going to excerpt certain records, you really got to make sure those are ones that tell the full story. And if they don't, you always have the right to send records yourself also. I mean, they should be subpoenaing any subpoenaed record you should get a copy of. So if their records are being left out and you see that, you don't even necessarily need to fight with them about it. You can just send them yourself. But I've just been calling the other attorney and saying, hey, can you also include this? And it's not been a problem.
Perfect. Yeah, because like you said before, I mean, it's your job as applicant attorney to kind of, fill him in on the story of the injury and how it worked for the applicant. And there's a reserve, and we're all looking out for the best interest of how to juggle both sides. But definitely. So what happens when there's a page? Well, that was the next question about the page count discrepancy between the parties and evaluating doctor. But I think, like you said, kind of working together on it and keeping the communication lines open to see, you said $30 to dispute it back and forth, probably not going to be much. So let's move to the next one. Since this has been in effect for a couple months now, what have you seen or experienced in relation to this change? Like, how has it ultimately impacted the QME process and forwarding of records?
Yeah, I mean, I think the main thing is kind of what I touched on before, that they aren't just sending all the records anymore. And so it's almost in a sense created more work for the applicant attorneys, because we do need to pay attention when we get the cover letter with the medical records to really look at what's being included. And so far, that's been the biggest change. You know, the defense attorneys I've talked to about it, they're not saying we're doing it to save money. Okay, they're not saying that to me, but I'm sure they have instructions from the adjuster to limit the page number to under a certain number, something like that. So the biggest change so far is just when they do send the records, especially in the initial evaluation, to really look at what's being sent. Because it's not just, you know, before they would send records like, oh, you got hurt playing football in high school. We're going to send these to the QME even though you're 62 years old. That they're not going to do that anymore, which is probably better for everyone. But yeah, you got to pay a little bit more attention.
Agreed. And is this taking you guys more time? Like you said, it's more on the applicant side. You guys don't get paid for stuff like this. It's diligent work. What have you done in your practice that has changed this?
I mean, I think that even though we don't necessarily get paid for it, you kind of get dinged by not doing it, because what they're trying to do is get the apportionment up. So they want to include records that are good for their side in terms of showing pre-existing injuries. So while you don't necessarily get paid, we would lose money by not doing it if they only send records that are helpful to their side. And that can influence the QMEs. And, you know, you only get one chance to make a first impression. And so it's kind of, doctors are not big on changing their opinions. No one is, actually, from what I can tell. But you want to make sure that first chance you get, or your client's first chance that they get, the full picture is being shown to the QME. So that's really what I kind of see as important, even if you don't get paid for it, you know, time-wise. There is a back end cost to it if you don't pay attention.
No, that's a great point. So some of the offices I've talked to, they asked, how are other firms handling this? What have you seen? Like you mentioned, there's that joint cover letter that Southern California offices kind of do more, or do you put this attestation and declaration with the cover letters? Like, what are you looking at?
I kind of make two documents, but yeah, what I do is I'll write my cover letter, and, you know, not to do a little too much inside baseball for how I do things, but I know everyone else does this too. Most cover letters, a lot of it is the same, right? You change the parts about the case, the facts of the case, the types of injuries, that kind of stuff. But a lot of it is also, please use Alvarez Guzman, please consider the kite case. The legal portion of it is boilerplate and the same. And I've seen that across the industry. And so now you can kind of just add in that template for if you're going to send records to that. So there's still going to be two different documents. You're going to have your cover letter that you're going to sign, but then you can have a second document that goes as a cover letter to medical records if you're sending any medical records, where you fill in the name of the case, you know, the date, the number of pages, and sign it. And again, you know, at the beginning of this, some doctors' offices literally sent me the template that they wanted me to use. And so I've just gone ahead and used that same template for everyone, because it was very easy to understand, basic. And so if there are applicant attorneys who don't know exactly what to include, I would reach out to some of the QME offices, especially ones that are handled by some of the bigger overarching services. I would imagine they would literally just email you a template that you can use to add at the end of either your cover letter or on top of the records that you send, just to make it easy for everyone. And I think, generally speaking, the doctors, all they want to see is that you basically complied with the thing. You know, that's all they care about, because they just want to make sure they get paid. They don't want to make it complicated, you know, but they want to make sure that they're following the rules. So I would get your hands on a template if you need one, or, you know, you could just write, this is how many pages it is, this is the date I send it, this is who I sent it to, sign it, and kind of leave it at that too.
Yeah. No, I've heard both sides. So some offices take more of a proactive approach and they're adding it in and putting it together. But like you said, there are those QMEs that come back and they have their own that you can pre-fill or they want it in a certain format. We have one here. It says, we've heard that some attorneys do not review their records and depend on the doctors to sift through the records. Have you seen an increase of time in your records review? And how much time do you allocate to review one set of records? And how has that increased with the new rule?
Definitely there's an increase in time, but I don't have like a certain amount of time I'm going to spend on one or the other. I think you've got to kind of understand the value of each case, and you've got to understand what cases are worth spending more time on than others. Also, like for instance, I had a case where my client was treating at Kaiser's Industrial Clinic, but she was also a member of Kaiser. And so there were just an unnecessary number of Kaiser documents. And so I looked at the ones that were sent as part of the cover letter, read through them, and they all looked fine to me. I didn't see anything in there that was missing. They did include the diagnostic test from after she had been injured. And so, no, I didn't then go back and read all 1,000 pages. That didn't seem necessary to me. What I was more concerned with was the ones that are included. Are they the ones that tell the story? And then also, again, for like the 5th, 6th time, got to make sure that the diagnostic tests are included. That's the biggest thing that's going to get you the PD and prove objectively that your client's injured. So that, and then the first injury report, they have to be in there no matter what. So it has increased the time for sure, but I don't necessarily allocate certain amount of time to it every time. I have spoken with other attorneys who are having their office staff go through them. That's something you could consider too, depending on how you like to work your practice or how many staff members you have, that sort of thing. But yeah, it's certainly more work for the applicant attorneys. And frankly, it's more work for the defense attorneys too, because before they would just send all the records and now they have to look through them. So I don't know what the cost benefit analysis is. At what point is paying the attorney X number of dollars an hour to go through the records cheaper than sending the records? But somebody definitely did that analysis at the insurance companies. So
we could only imagine with this fee schedule now.
Right.
So that leads to becking the question, what about duplicative records? How do you sort through those with the opposing counsel?
I would say now it's really important that you don't do it. And here's why. The doctors they can't charge for duplicative records. It specifically says in the fee schedule that they can't write a report based on records that they already have and then get paid for that report. So if you send duplicative records, you're just going to upset the QME because they're going to have to kind of work for free because they're not going to know they're duplicative until they actually read them, right? So as just kind of, don't upset the person you want to be on your side. Don't do that. Also, it's a waste of money. If let's say the doctor bills for it and the insurance company doesn't catch it because frankly, they're not going through every single thing too. Now you've just wasted money and time in your case. You've wasted the reserve in the insurance company case, and it might take the doctor longer to rate the report if they have to go through 250 pages of duplicative records. So I would make sure to try your best to not do that. That you shouldn't have done it before, but I think now specifically because the doctors, it says in the regulations that they can't get paid for information that they already have. So if they're writing a report based on no new information, they're not going to be paid for it. So you don't want to waste the doctor's time.
Yeah. It's a lot of correlating back and forth with the parties, making sure you agree on what's being sent. And it's right. Like you said, painting that full picture.
Well, and that's another reason, even if technically you don't have, after the first evaluation, you don't necessarily have to have the time limits. It's a good thing to send it to the other side too, just as a kind of make good with people, because the defense attorney is the one who's going to get in trouble if the duplicative records get sent, they get billed, they get paid, and then they realize down the line they spent $700 on something they didn't actually have to pay for. The defense attorney is going to be the one who gets in trouble for that. You don't want that to happen for something stupid like that. So it is a good reason to work with the other side.
Agreed. And ultimately, like costing your client the injured worker, right?
Good, yeah.
take away
Yeah,
from.
certainly. And I can't say for sure that's how it really works in terms of, the reserve is this or that, but that's what I hear constantly, and it makes sense to me. So I can't see how wasting money ever helps my client. That just doesn't make sense to me.
No, agreed. So ultimately, this fee schedule will significantly increase the costs of med-legal evaluations with the new multipliers and further increase with those. So how do you see the future of this going, and what are some of the obstacles you can maybe see coming up?
I think a few things. One, I think it's going to lead to parties, or especially the defense side, being hesitant to ask for supplemental reports at all. So you might lead to a situation where you have some leverage in a settlement discussion, because you can say, hey, look, we can either sell the case now, or, I have 500 pages of records that, I want the doctor to review, and they are applicable to this case. So that's going to cost you X. Can we sell the case instead? That has not yet happened, but I think as we shift back to more in-person events, that's going to happen a little bit more, because in in-person events, the dynamic changes a bit. Also, people seem to be more prepared when they're working at home for whatever reason. I don't know, but there's that. There's also now that depositions are going to cost more. So in the past, the way depositions worked is I usually had to send the doctor $500 up front to pay for the deposition. And that was there wasn't necessarily a rule about that, but that's how all doctors' offices operate. They wouldn't even let me in the door unless I brought a check with me or mailed it a couple weeks beforehand. Okay. Now there's a specific dollar amount that it costs, and everyone knows exactly what that dollar amount is. It's $455 an hour, but you have to pay up front for 2 hours. So everyone knows it's $910 that you have to send. So as an applicant attorney, we're not used to paying costs up front for workers' comp cases, and every other sort of legal field attorneys pay costs, but not workers' comp. So attorneys have to decide, okay, do I want to send $1,000 over and probably not get repaid for, a few weeks on that? So that might influence your decision, though I will say, as a practice tip and an ethical tip, if you think that it'll help your client, you have to bite the bullet and just pay for it, because the insurance company will reimburse you. I do see actually now with the cost being set that you should be reimbursed more quickly, because you just say, hey, I set the deposition for this date, I sent them the check, send the insurance company a copy of the check. There's nothing to fight about. We know exactly how much it costs. So that should actually help being reimbursed more quickly, which is yet another reason to be on good terms with the defense attorney and the insurance company, because if you've been causing problems for them, they're less likely to do things like this for you. So I do think it might change how many depositions are being held. It might also limit the amount of supplemental reports that insurance companies just throw the kitchen sink at the doctor. Football injury, 1973, that might just not happen anymore. It might not be worth it to them to go down that road. So there's probably going to be a little bit more of a cost benefit analysis to the whole thing. I will say one thing that a little bit concerns me, and this more has to do with maybe unrepresented workers, is that because the initial QME evaluations might now be more costly than they were previously, there might be a lot of attempts to settle the cases before even the QME evaluation, which I generally feel usually doesn't help the injured worker out very much. But I'm not sure how we'd even find that out, because they're not going to have attorneys. But that could be kind of a downside to it. But yeah, I mean, I think that the bigger issue will just be if there's egregious examples that lead to a board decision, and board decisions oftentimes complicate things instead of making them more streamlined. It could lead to a lot more hearings, a lot more litigation. And frankly, I hate fighting over stupid things like this. And I know judges absolutely hate it when you come in there with a QME fight. Oh, he's an orthopedic doctor. No, he's a spine doctor. Well, they're the same thing, blah, blah, blah. So that would be my biggest concern, outside of even just kind of, the practical stuff, is, does this lead down a road where all of a sudden now I have status conferences set on which pages can be included and which ones can't? That has not happened, and hopefully it won't. But again, I think at some point the board will have to clarify some of the rules, and hopefully they make it easier for everyone to understand and follow, as opposed to more complicated. But we'll just have to see.
Yeah, always upside and downsides to it. So one last question. I know it wasn't on our review, but do you know if this applies to SIF cases? That's a whole different realm.
So I think it does. And the SIF people that I've spoken with, they certainly think it does too. But that's an issue. I mean, SIF cases can have tens of thousands of records. I mean, is a doctor going to bill $50,000 for record review? I think they have been so far. So I'm not exactly sure. My feeling on that, and this is just conjecture on my part completely, is because SIF is a separate entity in a sense, and the government is more heavily involved, they're going to end up with their own rules about it that are specific. But at this point, it does not specifically say one way or the other. It is the attorneys, the SIF attorneys, the applicant attorneys that I've spoken with, it's their opinion that it should count. And the reason for that is they really want to make sure that the doctors they use for these things get paid, because SIF doctors, it's the same doctors over and over and over again. And so to make sure that the people they work with are getting paid adequately, they have been following the same rules when they send the records, the attestations, and all that kind of stuff. But yeah, that's a big question. I don't know. My guess is not too many SIF cases have really, well, none have really run the whole case since April 1st, because they take a while for the cases. So I don't know, but at the end of the case, if there's a $50,000 lien from one of the evaluators against SIF, I don't want the state to shut down the program because of it. But I don't know. That's a wait and see.
Whole different thing. Yeah. No, I think with any of these changes or schedules and things that come out that are new in the industry, like you said, there's always ups and downs about it, and we're just going to have to let it play out and see how it goes. But I appreciate you jumping on with us. I know we've only got probably 9 minutes left. John, did you want to open it up for some questions outside if anybody has some?
Yeah, if anybody has any questions right now, you can go ahead and either put them in the chat or in the Q&A down bottom. I don't see any that we haven't addressed right now.
Yeah, I think so far we tried
give it a minute or so and see if any come in.
Yeah, we tried to move along with them as we went through. This is an interesting topic. I know everybody's kind of addressing it differently in their own way and having unique experiences, but thank you, Rob, for coming on.
Yeah, I would just say my last point is, although I think there's some problems with it, I'm hopeful that the main benefit will be that more doctors will want to become QMEs. Like, to me, that if only that happens and the rest is a cluster, cool, fine. Like, just the number of QMEs that we have in the system right now is not working. And so if we can encourage more doctors to come in and be evaluators, we'll deal with the rest of it, because waiting, 6 months for a QME evaluation because you're on your third panel, not only does it make it look like I'm bad at my job because my client doesn't get it, but it's also, by that point, it's no longer a reasonable evaluation because that injury happened so long ago and maybe they haven't gotten any treatment. So if that happens, the rest we'll put up with.
Yeah, no, definitely an upside to it. There's a million different things that this could play out to be, but
true.
We'll see how it goes. I really appreciate you being on here. I think we're good. I think everybody got all their questions. We've hit on the main points, and ready to wrap up.
Thank you, Robert, for coming on.
Absolutely.
We have recorded this, so this is going to go ahead, like I said, on our Zoom channel, on our YouTube channel. So if anybody wants to take a look at the recording after, we'll have that available within a couple of days. Thank you for Marie for doing such a great job as the co-host here.
Absolutely.
Thank you.
I hope you all have a great rest of your day.
All right. Thank you very much for having me. I really appreciate it.
All right. Thank you.